Okay, let me start that over. After the 36626, in which the appellant was present, and the docket even states such, and the courtroom staff saw her as they exited the hearing and upstairs in the clerk's office while papers were given to the guardians. She knew this court would require exterior factors to operate fairly. In the time between the 6626, a redress of grievances, a third amended complaint, and visitation petitions in other children's cases were filed, with ill results in the family court in Sacramento. Due to this juvenile case, the appellant sought formal disclosure or dismissal of the juvenile case due to failure to disclose paperwork. All the efforts of the appellant were given to the trial court with the JV 180, and that same day the appellant received an email. The requested documents were ready. The addendum to the JV 180 motion to dismiss introduces exculpatory evidence held by the department and the implications of this new evidence. According to Quest Diagnostics, no test was done. This is clearly not what the department claimed when they seized child K a second time. Another piece of exculpatory evidence is an unaltered copy. The results initially submitted to the court and received by the appellant for the first time during habeas corpus. Facts are: two versions of one document exist. No facts follows the submission to Quest Diagnostics in the file that Quest requested to clarify what tests should be done. The MRO had questions and was not allowed to speak to parents or caretaker. After 7 days, a claimed response was of a positive test, but actually the sample was discarded, as Quest Diagnostics said they would do if no reply was received. No test is the last statement Quest makes in this test. The court not only ignored these facts that exonerate the appellant's family, but it minimally puts the department's claims in general in question, which would justly call for a hearing of such new evidence. I reiterate facts of both parents of child K. Drugs are not of concern. Rodriguez of Sacramento HHS claims of mother having DUIs are false, and no arrest happened in 1999. No parent has been seen with drugs or using drugs, and these pictures that do not exist of paraphernalia have never been heard or produced. The levels, if true, should have caused immediate hospitalization if concern existed for child K, not days later and filed during mother's courthouse protest. Any child's paperwork was received and served with the same dates. Another child's paperwork was received and served with the same dates of the hearing. If the court had fairly heard the appellant, she would have disclosed she actually went to this child's home and spoke with his mom. And this other child is the same age as child K and had medical issues. Had the court heard the appellant's argument, it would realize this appeal and case could have been avoided completely and would have ordered mediation as offered to the department counsel prior. An extension of the system cannot survive without cannibalizing itself economically, then amputation may be necessary for survival of the system, especially when inverse definition to action ratios are known by all actors of the system. Parental unfitness needs to have a clear and concise criminal charge of similar scope of accusation to prove preponderance liberally construed when the intrusion is such as the scope to remove a child from a home. Harm to the child should be, in addition of a physical nature requirement, emergency, minimally urgent medical care. 4 days later without seeing a doctor, or a warrant 7 days later and a court allowing such hearsay is unacceptable. Proving parent unfitness first before intrusion is well argued and agreed to by the latest Texas Supreme Court amicus curiae. Thank you, Parental Rights. Although preponderance is a level of evidence reach in the argument. Contested evidence should be heard unless exigency exists and is provable with criminal or medical history beyond liberally construed hearsay facts. The truth in this case is the parents' liberty rights have been intruded upon as to literally search through drawers, fishing for reason to seize child K. When a reason could not be found, the department was forced to alter evidence to give cause for removal, petitioned for on September 6, 2017, and re-petitioned on September 18, 2017. Some arguments do consist of evidence law in criminal matters, but the accusation in this quasi-criminal courtroom, labeled as juvenile dependency, uses liberally construed evidence to penalize a crime or potential of one, and sentence is of time withheld from the penumbra of self, so quasi-criminal argument is relevant. In addition, the accusations that stem from social workers not only apply to a parent-child relationship, but they also extend to the community, your job, your relationship, and every other aspect of your personal life, and therefore should be treated with such care as if charged with the crime. Even in a civil matter, where the debate is financial or of contractual nature, cross-examination is heard, and so is contested evidence. A good comparable to the parent-child penumbra of liberty rights would be a marriage relationship between husband and wife. Parent-child relationship is in the penumbra of liberty without any difference of respect and boundaries expected from law, as to live freely without government intrusion. This includes medical, educational, and religious decisions made by parents. America's greatest strength is diversity. It's crucial for sustainability. Individuals must be allowed to thrive without fear of exterior governmental intrusion. I will emphasize how important this matter is because a line has been crossed. Okay, big time. By intrusive social workers who believe they are the law. The absurdity of details is to regurgitate trauma, to consciously and understandably comprehend what has happened to this family is systematically explained as defined un-American.